Tell the truth, the whole truth, let no false word arise. Though your brain is doing somersaults and panics in your eyes. From the oath until the judgment, may your courage be true and bold. Jesus, know the judge be saying, I'm talking through me hole.
Imagine you're in an Irish courtroom. Someone points at you and says, "That's the person who did it." Scary, right? But the judge leans forward and says to this person, "Are you competent, compellable, sworn, and cross-examinable?" Suddenly it sounds less like drama and more like an exam. I'm Declan O'Lular QC, and in today's video we address the beast that is testimonial evidence in Irish law, who can testify, how they swear to tell the truth, how lawyers can and can't question them, and why you can't just say, "I told the Gardaí the same story, so it must be true." By the end, you'll understand why the Irish system is obsessed with live witnesses, questions, and fairness, and how that all ties into constitutional rights. Let's start with the basics. What counts as testimonial evidence? In Irish law, the star of the show is oral testimony, a live witness, in court, talking about what they perceived through their senses, under oath or affirmation, and open to cross-examination. That's different from real evidence, like a knife, documentary evidence, like a contract, and hearsay, statements made out of court by someone who isn't there to be questioned. The key idea is testability. Evidence should be capable of being tested in court under oath, notably through cross-examination. If it can't be tested, it's likely to be inadmissible even if it seems relevant. This isn't just a habit. The right to challenge evidence by cross-examination is part of a trial in due course of law under the Constitution. In other words, cross-examination is central to fair procedures and a fair trial. Before anyone opens their mouth, the law asks, is this person allowed to be a witness and can they be forced to testify? A competent witness is someone who can understand questions and give intelligible answers about events. The court focuses on capacity, not perfection of memory. A compellable witness is one who can be required to give evidence, with some familiar exceptions in practice, such as certain spousal or privileged situations depending on context. On top of that, testimonial evidence rests on a truth undertaking. The system wants evidence from a witness who understands the duty to tell the truth, either under oath, under affirmation, or, for certain children and vulnerable witnesses, unsworn but still intelligible and serious. The judge or jury then decides what weight to give that testimony, taking into account factors like demeanor, consistency, and corroboration. Next up, the courtroom's mini-ritual, the oath or affirmation. Irish law still uses a mainly 19th to 20th century framework. The Oaths Act 1909 provides religious oath forms, and an affirmation is available for those who do not wish to swear a religious oath because of belief or non-belief. Modern practice treats evidence given under oath and under affirmation as having identical legal effect, with the real point being that the witness formally undertakes to tell the truth. Law reform bodies have suggested moving towards a single secular affirmation for everyone to reflect religious neutrality. However, this has not occurred, and the traditional oath or affirmation structure still formally exists. Children and certain witnesses with intellectual disabilities get special treatment. Under the Criminal Evidence Act 1992, a child under the age of 14, or a person with an intellectual disability, can sometimes give evidence otherwise than on oath or affirmation. If the court is satisfied, they can give an intelligible account of relevant events. Finally, the Act stipulates that unsworn evidence can corroborate other evidence. Time to look at the choreography of questioning, starting with examination in chief, then cross-examination, and finally, re-examination. This is known as the elicitation of evidence. Lovely word, elicitation. Examination in chief is the first segment and consists of questions asked by the party who called the witness. The purpose of examination in chief is to let the witness give their own account of what they saw, did, or heard in an organized way that focuses on relevant and admissible evidence. This explains the big rule here: no leading questions on disputed or material points. Counsel should use open, who, what, where, when, how questions, so the story comes from the witness, not from counsel's suggestions. Counsel can bring their witness back to the path if their witness starts to wander, but the witness must be allowed to walk on the path by themselves. There are practical exceptions to this rule. Leading questions are allowed for purely formal or introductory matters, as this saves time. Evidence like name, address, or uncontested background, and sometimes for facts that are plainly not an issue to save time. Another exception is if a witness turns against the party who called them by refusing to answer honestly or contradicting earlier statements. The court may declare them hostile. At that point, the calling party can use leading questions and even prior inconsistent statements. And in some criminal cases, legislation like the Criminal Justice Act 2006 allows such prior inconsistent statements to become substantive evidence in defined circumstances. Cross-examination is where things can get dramatic, especially if it is a courtroom drama. The opposing party gets to test the witness's evidence. Its central aims are to test accuracy, honesty, and reliability, to expose inconsistencies or bias, and to put the cross-examiner's own version of events so their witness has a chance to respond. Cross-examination is constitutionally significant in Ireland. It is treated as a core element of a criminal trial in due course of law and part of broader fair procedures guarantees. Here, leading questions are not just allowed, they are standard, and a skillful cross-examiner will only ask leading questions, calling for a yes or no as a reply. The judge can, and should, step in if questioning becomes oppressive, abusive, or confusing, particularly with vulnerable witnesses. The scope of cross-examination can be wide. It may go beyond what arose in chief, covering any relevant matter and issues of credibility, including prior inconsistent statements and, if the character evidence door has been opened, certain past convictions or biases subject to rules. Importantly, if a party plans to later argue that a witness is wrong or lying on a key point, they must generally put their case in cross-examination, so the witness is confronted with that challenge then and there. Although not as glamorous or dramatic as tripping up the witness, their putting their case aspect is possibly the most important aspect of cross-examination. After cross-examination, the original calling party gets one more chance, re-examination. The purpose of re-examination is to clarify or repair matters that emerged in cross-examination, for example, to clear up ambiguity or respond to suggestions that the witness recently fabricated their account. The orthodox rule is that re-examination is confined to matters raised in cross-examination, unless the judge grants leave to go further where fairness demands it. As in chief, leading questions are usually not allowed in re-examination because the goal is still to elicit the witness's own explanations rather than counsel's version. However, courts can exercise discretion to allow focused leading questions where they are simply clarifying confusion created during cross-examination. Modern teaching materials highlight three core uses of re-examination: rehabilitating credibility after attack, clarifying ambiguity, and dealing with allegations of recent fabrication that arose during cross-examination. Now for the modern twist, testimony by screen. In criminal proceedings, the Criminal Evidence Act 1992 allows certain witnesses, especially children, complainants in sexual or violent offenses, and some others, to give evidence through a live television link, usually from a separate room. Their witness is still sworn or affirmed, still examined in chief, cross-examined, and re-examined. Only the physical location changes, not the nature of the testimony. The Supreme Court of Ireland has confirmed that the live television link, or Zoom as it is nowadays, satisfies the right of confrontation. The same act also allows video-recorded interviews with certain witnesses, notably child complainants in serious cases, to be admitted if statutory conditions are met and the witness is available for cross-examination at trial. In civil cases, legislation such as the Civil Law, Miscellaneous Provisions, Act 2008 and later measures permit evidence by live video link under court control, and procedural rules now even allow for remote swearing of affidavits with safeguards for identity and visibility. The golden rule is, as long as the witness can be seen and heard, is properly sworn or affirmed, and can be effectively cross-examined, the evidence remains testimonial even if it comes through a camera. Next, the law's sensible recognition that humans forget. Irish practice allows a witness, including an accused, to refresh their memory using a document either before going into court or while giving evidence, but only if certain conditions are met. Typically, the witness must say that the document was made or verified when the events were fresh in their memory, that it accurately recorded their recollection at that time, and that their present memory is significantly weaker without it. If a witness uses a document while giving evidence, the other side can inspect it and use it in cross-examination, potentially to suggest inconsistency or fabrication. If cross-examination starts cherry-picking parts of that document, the calling party can ask the court to admit the whole document so the fact-finder sees the full context. It is important to note that the admission of the note is not to admit the truthfulness of its content, as the note is hearsay, but it rather goes to the credibility of the witness. The trial judge should make this point clearly to the jury. Distinct from this, reading your own statement before trial is usually acceptable preparation, but the line between legitimate refreshing and improper coaching exists. Lawyers can explain procedure and test understanding, but cannot rehearse specific answers. Finally, why can't a witness just say, "I told the same story before, so it must be true"? Their rule against narrative, often treated as part of the rule against previous consistent statements, generally stops a witness from bolstering their credibility by showing they made the same statement on earlier occasions. Repetition alone does not make a story more likely to be true, and allowing endless prior consistent statements would both swamp trials and undermine the focus on in-court testing through cross-examination. There are important exceptions. In sexual offense cases, recent complaint, doctrine, and statutory provisions allow some prior complaints to be considered for limited purposes. Identification procedures can be proved despite the rule because of the specific risks around identification. And earlier consistent statements can be admitted to rebut allegations that the witness only recently invented their story. Statutory regimes, such as provisions allowing certain prior inconsistent statements of hostile or non-cooperative witnesses to become substantive evidence, also create targeted departures from the general rule, but always for a specific probative purpose beyond mere self-corroboration. So in Irish law, testimony is more than just talking. It's a carefully staged performance under oath or affirmation, framed by strict rules, technology, and constitutional guarantees, all designed to get as close as possible to the truth without letting the story turn into untested narrative theatre. I'm Declan O'Lular QC, and this has been The Law is My Oyster.
Tell the truth, the whole truth, let no false word arise. Though your brain is doing somersaults and panics in your eyes. From the oath until the judgment, may your courage be true and bold. Jesus, know the judge be saying, I'm talking through